Hi, everyone. I hope that you had a really great week, and thank you very much for joining us again for the third session of our board boot camp, which is on land transactions. So Amy's asked me to just say a couple of words introducing myself. I'm sorry if I'm repeating a little bit, but if you don't know me, I am representing tonight CLCC. I sit on the advisory council for CLCC. I work and live in the northwest corner of Connecticut. Specifically, I work as the executive director part-time for the Kent Land Trust. I work as the coordinator for the RCP known as the Litchfield Hills Greenprint Collaborative. And I'm a private consultant who works with many, many land trusts all over the United States on land trust accreditation and standards and practices. So I'm not sure if I got all of my hats, but it's really great to see all of you, and especially those of you that I've been able to work with before. So I'm going to share my screen. The information that we're going to be going through tonight is a little bit dense, and I apologize for that, but we will break now and then for questions. And please feel free to, as Rebecca said, post your questions in chat if they occur to you while we're going. And also don't be afraid, because these sessions are also about connecting with your colleagues, which is so hard to do when you're a brand new board member, and yet so important to know that there are so many volunteers just like you working on these issues throughout Connecticut. Don't be afraid to have a private chat with a colleague if you see somebody that you know. Perfectly appropriate. It's not even disturbing to me the way that it would be if you were having a side conversation in a regular presentation. So isn't that nice, right? Okay, so if I can see my arrows, let's dive in. Great. So as a quick review, these board bootcamp sessions follow along with the format of the Land Trust Standards and Practices, which are a body of guidance that is kind of crowdsourced from the land trust community and conservation professionals. And it's codified and maintained by the Land Trust Alliance, which is kind of CLCC's national counterpart, providing advocacy and supportive training and services to conservation organizations nationwide. The standards and practices, which were last updated in 2017, are comprised of 12 standards addressing important topical areas common to land trust practice, the first half of which pertain to all nonprofit organizations and the latter half specific to land trusts. And the standards also easily organized into 4 topical buckets, which are governance, which was last week's session, financial management, land transactions tonight, and stewardship. The standards addressing land transactions are standards 8, 9, and 10. And since this is an introductory course, I just want to briefly mention that land trusts protect property in 2 major ways. The first is through ownership of property, which in legal terms is called the fee interest. And the second way is by acting as the oversight organization for private property, which the landowner has restricted from development. And this is called a conservation easement. I know it's kind of basic, but just to get those out of the way, land trusts holding conservation easements do not manage those lands, but they do monitor them to ensure that the landowner complies with the restrictions. So it is typical that you're going to hear your organizations referring to your fee and your easement properties. Some organizations may have mostly one or the other. How they're taken care of differs, and that's called stewardship, and we'll talk more about that next week. But during the acquisitions or the land protection phase that we'll talk about tonight, both types of transactions have common planning steps and legal review that brings them from concept to closing. Okay. The material today is fairly detailed, as I said, because conserving a property is a detailed process. You might ask, if this isn't your role within the board, right? I got brought on the board for development or communications. If this isn't your role within the board to prepare these transactions, how much of this do you really need to know? And my answer is that it's a good idea to have at least a basic familiarity with what the process entails. Recall from last Monday that the board is ultimately responsible for overseeing the management and financial stability of the organization. And this includes being aware of new land protection projects and ensuring proper due diligence has been completed before voting to accept a conservation property. To bring this home, we'll return again briefly to Standard 3, addressing board accountability. The final practice in that standard there says it's the full board's job to review and approve every land and conservation easement transaction. In Connecticut, it's often the case that boards initially hear about a land protection possibility early on. They may discuss the merits of further developing and planning a property transaction and vote to move forward and potentially to incur some project planning expenses, like the cost of legal and environmental investigation, perhaps an appraisal if the project will be a purchase, such as is the case, for example, with the Open Space and Watershed Land Acquisition State Grant Project, otherwise known as an OSWA project. But regardless of whether or not a land trust takes a preliminary vote, and that's part of your land trust process, your board will vote prior to closing on any transaction, at which time you should, as a board, have available a lot of information about the project, including the results of site visits, analyses of conservation values, and due diligence items like the title investigation to help you make your decision. As you can see on this slide, there are exceptions, and large, well-staffed organizations may delegate the function of approving a land transaction to staff or a committee. But even then, the full board should be well briefed in a timely manner on any newly protected property. So I just want to get the chat up here. Well, that didn't work. I'm just going to continue. All right. Here is an example of a resolution to accept a conservation easement prepared in advance of a board meeting in anticipation of a final vote to accept the property. And as you can see, the resolution asks the board to conclude that doing the protection in question, which is accepting the conservation easement, is consistent with the land trust's mission and its project selection criteria, and that it will confer a public benefit. There's language in here about the organization's confidence that the transaction is feasible and that the organization has the resources to live up to its stewardship obligations. You'll note in this example, the approval came before the attorneys agreed on the final language of the easement agreement. So the resolution was made on the contingency that no substantial changes would be made to the description of conservation values, prohibited uses, and reserve rights contained in the draft language that was provided to the board before the vote, and that all other due diligence items and documentation required by the organization's procedures would be completed prior to closing. So it's okay to vote before everything is, absolutely in line. But what this resolution proposes is that if something material changes or new information that is germane to making the decision happens, then the board would revisit and vote again. And so how would the full board, many of whom will have not had insight into the many steps and detailed information collected on the project, know that it can make these findings of mission consistency, public benefit, and etc. The committee or the persons who are responsible for preparing the project should provide the board with enough information to make those findings, including a description of the conservation values and why they meet the organization's criteria for conservation projects, maps and photos of the property, and information about the structure and the cost of the project, as well as results of the due diligence conducted. And for fee property acquisitions, this would include at least a general idea of what type of management might be necessary or appropriate for that property, what the board proposes to do with the fee property they're accepting, such as installing a trail or a viewing area, as well as any management needs to protect the interest in the property, the organization's interest in the property, such as boundary marking and signage, and to protect the conservation values, such as clearing invasive plants as part of restoring wildlife habitat. Here is one example of a project summary which details the nature of the project, its location, maps of the project, of the property, including a survey, aerial and topographical maps, as well as where the property sits within the surrounding area of protected properties. The summary reports on due diligence items such as title work, environmental review, management needs, and projected expenses. Ideally, this, like all supplemental documentation provided for board discussion and vote, should be distributed to the board prior to the meeting to allow full review. Now, I have worked with boards who find that information about conservation projects can be very sensitive, and they don't like to distribute written information until the project is kind of assured of closing. There are likely ways to deal with this and still get the board the information that it needs, such as projecting the information on a screen during the meeting, works very well with Zoom, as you can see, and allowing ample time for reading it. You could also add a watermark of confidential to drive home to the board that it's not for distribution, or ask board members to delete or destroy all copies following their review. I've also seen occasions where if the public comes to meetings, and we were talking about that during last week's session, the board could take property protection discussions in executive session. Just make sure that down the road, the board's review of transactions and the records of what it saw prior to voting is documented. Okay, are we doing on time? Good. Now we're going to turn to the specifics of the standards and practices on land acquisitions. There are basically three phases to a property transaction. The selection of the project, which how you will know what to protect or whether or not the project that's being offered is a good one. Project planning, which is all of the investigation and legal work that's needed to make sure that the project is fully investigated, sound, and can achieve the conservation goal of the project in perpetuity. And the last phase, which is closing on the project and the opening of, your obligations to have files and record keeping and fully complete the project and steward it in perpetuity. Rebecca Washburn, who was our Land Trust Alliance rep, used to say, forever, it's such a long time. Okay, at the project selection phase, the standards and practices are about having processes to help land trusts plan for the projects or types of projects they believe are most critical. For some land trusts working in only one town, this might be a list of actual parcels. And for others, the priorities might be resource related, such as a farmland protection organization prioritizing working farms or land with prime agricultural soils, for example. An organization might have maps showing these priorities. It will also likely have a procedure for selection of projects, including written criteria to help determine whether or not a proposed project is worthwhile of the organization's commitment of resources now and in perpetuity. This final element of Standard 8 here under number 4, requiring documentation of public benefit, is one reason that I showed you the example resolution containing the board's finding of public benefit. So here are a few other examples of what we might mean when we're talking about not only strategic conservation planning, but project selection criteria. Okay. So this is a map showing a portion of Kent, where I live, calling out conservation priorities based on core forest areas and the connecting lands that link them. And you can see the Appalachian Trail in red and the Housatonic River kind of bisecting the map on the diagonal. And you can see that here on this map, the parcels are added, right, showing us where the larger parcels are, and also hash marks where land is already protected to help identify where, additional land protection will be most meaningful. And here's an example of project selection criteria, also from Kent, although I have to say many community land trusts have very similar criteria. I've highlighted here a couple of things, including the potential for public recreation, projects adjoining or near to existing protected areas, wildlife habitat, especially for endangered or state-listed species, and perhaps farms. Okay, so they can be different or they can be really, very similar to this depending on the nature of the organization. Okay. In addition to meeting a land trust's priorities and project selection criteria, no deal should go forward without at least one physical visit to the property. And I would bet that most land trusts in Connecticut visit prospective projects many more times than that before closing. The site visit is another way to ensure that the project meets project selection criteria by providing ground truthing to what might have been seen on maps and GIS data analyses. The site visit also provides the chance to assess the quality of the resources, evaluate any threats to those, such as the risk invasive plants might pose to wildlife habitat, for one, and identify risks that are associated with the project, which might include risks of encroachment or environmental liability. More on that in a moment. Also, in connection with project planning is the concept that each protection project should be individually planned, which importantly includes a close look at the stewardship implications of each project. In other words, what the organization imagines its stewardship might entail. For easements, this is annual monitoring, but of course also the potential for encroachments and the potential cost of that. And for fee properties, it includes the management activities that are anticipated on the property. So looking at an easement, for example, prospective stewardship costs could be low on one hand for an easement with few reserve rights, that's easy to monitor and with low potential for encroachment. So let's say a 5-acre parcel with no structures, no reserve rights, that's with easily ascertained boundaries, like a stone wall going around all of it, and no neighbors, right? That's like the dream easy easement to monitor. Or something that, in opposition might have high enforcement costs, high stewardship costs. So imagine an easement that's, say, 450 acres, that's irregularly shaped, bounded by several subdivisions under development or with new people moving in, and there are reserve rights to, say, build a clubhouse and recreational facilities in a floating area of the easement. I hope none of you have that situation. But that is a place where, you'd most certainly have some pretty high stewardship costs going forward. Looking at a fee property, prospective stewardship costs could be low on one hand for an easy to monitor, forever wild property bounded by state forest and requiring no ongoing management at all with no public access planned. Or on the flip side, high for a property with a house that you're renovating as a wildlife education and research center, and the property will have 10 miles of trails with interpretive signage, as well as several project demonstration areas to accommodate school groups visiting from all over the state. So, that sounds awesome, right? But you know that in accepting a property like that, where you're making a promise to provide that kind of management and activity, it's going to be much more expensive. Okay, closing out Standard 8 is a practice that's focused on protection partnerships and collaborations. And basically what this practice sets forth are some areas that should be clarified and documented in order to ensure sound protection of the land and avoid disagreements and dysfunction after closing. So some of those areas might include just, setting forth the project details and the purpose of the project, who's financially responsible for project costs and other aspects of taking care of the project, including, ongoing stewardship and management costs. Okay, we're going to pause for some questions. And if I can get my toolbar, oops, sorry, let's go back to pause. I can get my toolbar.
So Connie, I don't see any questions in the chat just yet. Again, folks, feel free to post those now, or if they come to mind. I always find it helpful so I don't forget. But if you have a question right now and you don't feel like typing it out, if you go down to your toolbar, you'll see a little smiley face with a plus. It'll hit reactions. If you click on that, it says reactions, and you'll have all these different icons. You can raise your hand so you jump to the top of our list. Or if we're feeling particularly quiet, you can just unmute and come on out. Oh, so there's, do you see it, Connie?
I do see it. Eric has asked if there are state funds to help small land trusts defend easement violations. Not as such. I would say that, look, two two things. What land trusts are told to do, and what's a really good idea in connection with easements, is to put away or at least board designate funds that can be used for, for defense and of encroachments. And then the other aspect of that that's related and also private, not state funded, is that land trusts for the last maybe 5 or more years have been able to participate in an insurance program, and that's called Terra Firma. And that will provide, some relief from damages that or costs associated with defending one's easements. However, what is available on a state level is that we have very, and Amy, maybe even you could chime in on this. We have very, very favorable laws that help to prevent frivolous lawsuits by allowing land trusts to recover quintuple damages in easement encroachment cases. Amy, do you want to say that better than I have?
No, I think you said it just right. And what I'm going to do is I'll put the citation in the link in the chat for you, the link to that statute, as well as the section in our on our website that talks about it a bit. But yeah, it's actually one of the best, most stringent laws in the country when it comes to dealing with encroachments and allowing land trusts to collect the damages that Connie had alluded to, which is 5 times the amount. So it's a really good law. And oftentimes, oftentimes, it just takes a letter to the landowner and or their insurance carrier and or their attorney just pointing out that statute. That will be enough to get them to back down and cooperate.
Yeah. And I'll answer John's question from Joshua's Trust that the terms conservation restriction and conservation easement tend to be used interchangeably. And does CLCC have a preference? I don't know if CLCC has a preference. I don't really have a preference. The reason that you see that is that the law on the books of the state of Connecticut uses the term conservation restriction, but what it is the same thing as a conservation easement, as that term is used, on a federal level.
And I'll just jump in to add that, and I can put that section of the statute in as well, but conservation restriction is more, it includes conservation easements, but it can also mean a deed restriction, a covenant. It's a little more, it's broader than a conservation easement, but if you use a conservation restriction in place of conservation easement, it's fine. Okay, and then Rick has asked, how elaborate does a land trust case for public benefit need to be for fee simple acquisitions? And this is also kind of a moving target. There have been times where towns usually have tried to argue that land trusts should pay taxes on their fee simple properties because they're not providing a clear public benefit. And usually the way that is pitched is that public benefit means public access. So if you're not allowing the public on your properties, that somehow means that they're not conferring a public benefit. The law has not followed that reasoning. And so, generally, we working in the conservation field have recognized the public benefit that inures just from protecting water quality by, protecting large blocks of core forest, or air quality, or wildlife species, that all of those things are a public good. And so, I don't think that your case ever needs to be very elaborate, but if for some reason you find yourself questioning whether or not you're actually conferring a public benefit by protecting a property, I think that would, that would send up a red flag. It's worth having a discussion about that if it's not clear.
One question, I think we might have just popped over it from Scott at Joshua's Trust. He says, with limited resources, would you focus on fee properties or continue to focus on fee and easement properties in relation to costs and volunteers?
Oh my God, that's a hard question. Very debatable. And I think it also could there could be different answers for different organizations operating in different communities. So you just kind of have to find your sweet spot. Management costs can be high for the wildlife center that I was describing, but they can be high also for, very complicated easements. And certainly if there's an encroachment, requiring, substantial defending, that can tally up the expenses as well. So I really think that it's worth a discussion with your other board members and, find the thing that works best for your organization. All right, are we ready to move?
Looks good. And Amy's just dropped one of those statutes into the chat, everyone.
Thanks, Amy. All right, we're going to get into Standard 9, which is more about the project planning and due diligence phase. The first two parts of this standard deal with getting the expertise needed to do the project. The land trust should have legal representation for each and every project, but it also might benefit in some cases, such as the nature center that I described. That must have really been on my mind, by the way, while I was preparing for this, because it keeps appearing in my notes. But anyway, in some cases, it might be beneficial to get the expertise of other professionals to fully investigate whether a project is feasible or determine the extent of risks and one's ability to mitigate them. And the flip side to obtaining independent legal advice for an organization is ensuring that other parties have independent representation as well. So the ethical need for us to refrain from even giving the impression that our organizations could manage to act in both our own best interest as well as another party or entities. It's so important to avoid that it's really best practice to put in writing the recommendation to landowners and others involved in the project that they should have their own counsel. So, it might be the case that, the other party that you're dealing with decides not to get their own attorney, but I would never advise that. And instead, I would really encourage them not to go that route. An important part of project due diligence is environmental investigation to identify risks that include potential liabilities to the land trust. So the first steps of this might include the site visit. So remember back in Standard 8, we were talking about the site visit and some of the things that you can get out of doing that. So during the site visit, it's possible to make a physical inspection of the property and look for any red flags. But depending on what you find, you might not stop there. So past human occupancy might, for example, involve the buried oil tank or other potential contamination of the soil or water. I always use the example of when somebody's trying to give you the site of a former dry cleaning operation, right? Structures might harbor hazardous substances like asbestos. So, and past farming maybe might have contaminated soils with herbicide residues that might need restoration prior to hosting, say, like a community garden, right? So in these and other cases, public record searches, interviews with the landowners, and finally, outside expertise in the form of a phase 1 environmental assessment might be necessary. And the title investigation can also be helpful in this regard. So more about that in a moment. Due diligence also includes making sure that the property's boundaries are known. Monitoring properties and enforcing conservation restrictions in areas within properties can be difficult when the boundaries are unclear when one is on the site. If it's difficult for you to know as a monitor, then it's also difficult for those that are obligated to respect the boundary to know. So the best case is to have a survey map that shows lasting physical monumentation, such as iron pins marking the coordinates, and physical landmarks such as stone walls can also be helpful for ensuring that boundaries are easily recognized. Of course, once you protect the property, you're probably going to post the boundaries with small signs to help monitors know that they're in the right place, as well as people who are meant to respect boundaries. There are times when exceptions might be made where you might proceed with a transaction without having a survey map, but these are kind of case specific and maybe beyond the scope of tonight's meeting. Bottom line, what you really want is a survey for all properties that you are considering protecting. Conservation easements are a special tool that are strictly regulated by the IRS. And to satisfy the law and Treasury Department regulations, they must contain certain clauses that are related to their perpetual ability to protect the property's conservation values through the restrictions that are placed on it. So as important as it is to have a qualified attorney represent the land trust in each transaction, this is doubly true for conservation easements, because it's really important that you have everything in there that you need to in order for it to be recognized as a conservation easement and perpetual in nature. Luckily for us in Connecticut, CLCC prepares and maintains a template easement that's compliant with federal and state laws and with model provisions that contain the most up-to-date recommended language. So I hope that you will make sure that your organization adopts the CLCC easement template, which they keep updated on the website, easily accessible every time that you're going to need it, and also make sure that your council is aware that that exists. Okay, in the case of projects when the organization is buying the property, the standards and practices provide guidance for establishing the fair market value of the property as a basis for determining the purchase price. As a nonprofit organization serving a public purpose and using donated or grant funding for the purchase, it's not appropriate to pay a premium above market value, except in very rare circumstances. And in fact, most land trusts seek to purchase at below market at a discount whenever possible. Getting an independent appraisal helps substantiate that value and provide support when negotiating the purchase price. So taking a quick detour from this slide for the moment, and the slides, by the way, if you haven't realized, because they don't match exactly what I'm saying, but these slides are giving you the text of the standards and practices, and I'm trying to kind of paraphrase and make sure that you're aware of the things that you should know. So I hope that's not too disjointed. But we are going to detour from the text for a moment because I thought that you would perhaps hear the term bargain sale, and this is when a landowner sells at below market value at a discount. And so in that case, the difference between the fair market value and the purchase price can be considered a donation for the purpose of one's tax return. This type of project structure can work really well for some landowners, and so they should always consult with their tax representatives when you're trying to figure out how to structure a project transaction. All right, you might also notice that I'm jumping around within Standard 9. Here we went from E to H, and we're now going to backtrack to F, and that's because personally, I feel that the order gets a little wonky towards the end. So what we're going to do is cover the most important and sequential aspects first, rather than go alphabetically. Okay, so title investigation and recording. For all transactions, conservation easements and fee properties, a title investigation is one of the most important components of due diligence. There are several reasons why it's a good idea to begin title investigation as early as possible in the project planning process. Number one is that you'll want to make sure that the prospective donor, seller, person intending to convey the property is in fact the legal owner of record. And believe it or not, transactions have in the past been negotiated and even completed with parties who had no right to convey the property or an easement. But it's also important to ensure that there are no encumbrances on the property which could prevent the intended conservation from happening. For instance, a conservation easement cannot qualify as a perpetual restriction on the property if it is subject to a mortgage. And that would also imply the potential foreclosure by the bank. So conservation easement land must be released from the mortgage or subordinated before an easement can be completed. Another example, however, would be rights of access over the land that the organization wants to protect for sensitive wildlife habitat, right? So if you're protecting, say, a vernal pool and someone else has the right to build their driveway right through it or to install some kind of, telecommunications line, then, that's obviously something that you want to know and deal with before you close on the transaction. Sometimes it's the organization's own access to the property, which might be complicated and need further investigation and possible mitigation due to what's revealed in a title search. So while it's best practice to conduct the title investigation early on, it's also customary, as well as best practice, to update the investigation, which is usually called doing a bring down or bringing current the title investigation just before closing in case any encumbrances were placed in between the initial investigation and the closing. Following closing, it's important to record the new legal documents in a timely manner to make sure that the organization's interest in the property is known and protected. I'm not going to spend too much time on this slide, which is about what to do when the organization sells a property or conservation easement. It's a rare occurrence, but it might be a very good conservation strategy for a land trust that's offered a property, the entirety of which is not critical for protection. It's also, the model that's used. You might hear buy, protect, sell, based on this type of scenario in which the income from the sell helps to fund the buy. And that ensures that the part of the property that really is critical for protection can in fact be protected. Really good strategy making that conservation possible. So know that it's here in the standards and practices. It doesn't come up all that often. All right, a last concept in Standard 9 is not just about project planning and due diligence. It's about maintaining essential records to ensure the continued protection of the organization's interest. In other words, maintaining proof that the organization owns the property or holds the conservation easement through legal instruments recorded on the land records, and also demonstrating for easements that the organization is fulfilling its legal obligations of monitoring and enforcement. So a record-keeping policy, which is required of all nonprofits by federal law, helps to maintain the regularity of business practices necessary to allow for documentary evidence to be used in litigation. And it ensures the credibility of such evidence. So what did I just say? What I said was, having your record-keeping policy, following it, is really going to go a long way to making sure that if you needed to defend a property, that you would have the documents that you needed to do that, and that those documents would be admissible in a court of law. But none of us hope that we end up in court over our property. And so, really, just as importantly as protecting and maintaining your legal evidence, it really helps to have a record-keeping policy to keep us organized and focused and efficient and accurate in all of our dealings with our properties, especially when many of us are working in almost all volunteer organizations. All right, we're going to pause. We're through Standard 9. How are we doing on time? Pretty good.
So Connie, there's a question in the chat from Richard from Avalonia, just asking, how recent do property surveys need to be?
So I don't know that I, not being a surveyor, can put a hard and fast date on that. I do know that when you're doing an OSWA transaction, that your survey needs to be pretty up to date, and there were these, there are times in which like the standards change for surveyors, and so I believe it was like sometime in the 80s that that you needed to switch over. Most people shoot for a Class A survey as opposed to a Class D. Which in my experience has always been more of like an older survey, but maybe that's just because after a certain point, people didn't order a Class D all that often. Bottom line is your survey should be legible, and it should have, the most up-to-date information as possible. So, if your survey is showing a time when the parcel was configured differently, or if there's monumentation now that isn't reflected on the survey, it would really be in your best interest to have a survey that is more up to date and more helpful to you in finding the boundaries on the ground, and also, having a survey that people feel is reliable, so that if you should have to defend one of your boundaries, there's, no dispute and no discrepancy. Another thing that's occurring to me, of course, is that whenever you are purchasing or receiving a property by donation or conservation easement, that there's a property description appended generally to the legal documents, and those property descriptions, if they're not, blow by blow meets and bounds, will usually make reference to a survey map. And so the map that you have should be the map that is referred to in the property description that is that reflects your interest in the property. I hope that that's helpful. You got any others?
That's it for questions for now, unless anyone has a last jump in here, but I'd say let's keep going.
All right, great. So Standard 10 is about tax law, and it exists to help guard against abuses of the tax laws by bad actors who might try to inflate the value of their donated conservation property. Landowners who donate conservation land or easements are allowed to claim a charitable deduction for the value that they've given up by deeding the property or restricting their ability to develop the property through a conservation easement. To claim a deduction, landowners must file a form, IRS number 8283, which gets signed by the land trust receiving the donation. The form contains information about the value as determined by an appraisal. While it's not the land trust's job to come up with the value of donated property, and this is true for other non-cash gifts too, such as artworks or vehicles, it does protect us all from the potential loss of the conservation easement tool, from some who would prefer to see it go away because they don't like the abuses that can be made of conservation easements. So to protect us all from the loss of using that tool, and protects us from attacks on the credibility of the land trust movement if we take some responsibility for ensuring that the landowner's paperwork satisfies tax law requirements. In addition, it may put our donors' mind at ease when we offer feedback on unintentional mistakes. No one wants to get audited themselves, and an organization that cares about its donors should take steps to help them avoid a really stressful experience. Specifically, the standards and practices direct land trusts to let prospective donors know that there are conditions to making a charitable deduction claim in connection with their conservation gift. They should do this in writing, always advising the landowner to get his or her own independent counsel, including legal and tax advice, and with the express disclaimer that the land trust does not provide legal or tax advice. The information provided to the landowner should be boilerplate and should make a reference to the Internal Revenue Code Section 170, including at a minimum that there are requirements for the donor to get a qualified appraisal, and that the land trust will need to see a copy of the appraisal in conjunction with the Form 8283 and its signing of that form. It can be a good idea to remind the landowner of these requirements at tax time, like now, or even before now, maybe early in the year, especially if you receive the donation like early in the year prior. So if you got the donation in March of 2020, by January of 2021, the landowner may well have forgotten about their need to provide the paperwork associated with their donation. And so it's a good idea and very helpful to give them a little nudge, especially so you don't get presented with that Form 8283 and appraisal, 3 days before the tax filing is due. The remainder of Standard 10 is about the responsibilities of the land trust after the written communication to the landowner to review on its own behalf the Form 8283, along with the appraisal to determine that the required components are included for each of the form and the appraisal, and that those match. If the land trust has reason to believe that the information is inaccurate, it should take further action to address this rather than signing the Form 8283. And as you can see from Practice C in Standard 10, some suggested ways of addressing concerns about the 8283 include sharing those concerns with the landowner, seeking additional substantiation of value. So you might reach out to an appraiser, a different appraiser, for example, withdrawing from the transaction altogether, or refusing to sign the 8283. And there is also, down on number 4 within this practice, an item aimed at identifying and flagging syndication deals, which might exist when land is owned by multiple unrelated parties, often marketed to the land trust instead of coming to you kind of word of mouth or person to person. These transactions are rare in our state, but we should be on the lookout because they are the ones that are the source of some of the abuses of conservation easements that threaten this tool. Okay, the last new bit here, and somewhat of a preview for next week's session on stewardship. For easements, part of putting together a project is the preparation of a baseline documentation report, or a BDR. BDRs may be used by easement donors as part of their tax return, and they are required by tax law. But for land trusts, on our part, BDRs establish a record of the property's condition at the time the easement is given, providing evidence that's useful in any future enforcement matters, and especially in the event of litigation to defend an easement. BDRs are technical. They should be prepared by experts that are able to evaluate the conditions of the conservation values protected by the easement and the protective nature of the restrictions contained in the easement. They document these conditions through text, maps, and photos. A BDR should be ready to be signed by both the landowner and the land trust at the closing of the easement transaction. Following signing, they should be stored in accordance with the organization's record-keeping policy to preserve their purpose as legal evidence. There's lots more to say about BDRs, including their usefulness in monitoring and stewardship, and when they might need to be updated, but all of that is for next Monday. So we have the top 5 takeaways from this week. Number 1, that land transactions involve many detailed steps. Organizational procedures and checklists can help ensure that everything necessary gets done. Due diligence, number 2, is really important to making sure that you do excellent and lasting land protection. It's really worthwhile to be thorough and take the time that's needed, as well as to invest in getting the advice of professionals when necessary. Number 3, documentation is key. Long after we're gone, a judge should be able to tell that we followed all the necessary steps. So make sure that when you do all of these steps, that you have some way of documenting them for the record and preserving them in your project files. Number 4, the reputation of land conservation is dependent on sound transactions, free from abuse of the conservation easement tool. So by now it should be obvious to you that the standards and practices place a lot of emphasis on sound and defensible easement transactions. And number 5, acquisitions are really only the beginning of a responsibility to protect a property's conservation values. So please plan accordingly. I have that last note there that protecting land is super rewarding, as I'm sure you all know. And if you get a chance, I mean, these are the basics. I told you you don't have to memorize it all, but if you have the opportunity to serve on an acquisitions or land protection committee, then please do. It's great. And with that, here's my doggo slide, always all ears at the end of my presentation. Let's stop, take any remaining questions that you might have. Also, my contact information, as always, is here if you'd like to get in touch after you've had the chance to kind of digest some of this material. I'm going to stop sharing.
Yeah, Connie, we've had a few questions come in through the chat. The first one I see is the question is, if a board member owns property abutting a land trust property, is it a conflict for said board member to participate in review of acquiring another parcel to add to that preserve?
Well, you asked the question, so that's a really good sign because it's got you thinking. I tend to be extra conservative when it comes to conflicts of interest because I just think it's better, unless like every single one of your board members would be taken out by, having a really conservative stance, you're going to have enough board members to vote on this particular transaction and still remove the board member that somebody could say, hey, he or she could have been acting in their own best interest rather than really thinking about the best interests of the organization. He or she has a real incentive to want to see, the area of protected property expanded or not have a house put up next to them. So my personal leaning would be to consider that a conflict and have the person recused from discussion and decision making. But even the fact that you're thinking about it is a really good sign.
Awesome. The next question is from Janet at Wyndham Land Trust. Her question is, are there ever situations where alteration of an easement allows actions on the land that were previously prevented by the easement?
Sounds like we're talking about an amendment to the easement. And God, I guess that must be in stewardship because I'm like, I know I would have talked about that if it had been in today's lesson. Amendments, as you may know, are anticipated to be very, very, very rare. It's kind of like, it's supposed to be a rare circumstance, and the IRS treats it with a lot of scrutiny because when you make a conservation easement, you're meant to be doing it in perpetuity. But most of us in Connecticut and land trusts that are accredited all over the nation have a policy in place that governs how they would treat requests for amendment. And we are going to cover it next week. So the short answer here is that in very rare circumstances, if there were no negative impact to conservation values and hopefully actually a positive benefit to conservation values, you might amend an easement to allow different activities, so long as the initial conservation values and purpose of that easement continued, was not frustrated by what you changed. And you should do it really, with a good deal of analysis and discussion. And we'll do more talking on that next week.
Excellent. I see up is from Lee at Wolf Den Land Trust. Does your land trust typically target specific properties, or does most of your acquisition work involve properties that landowners offer to you?
I think that the answer to that depends as well, and it could depend on the organization. And it's a vast generalization, but in the almost 15 years that I've been doing this work, I would say that land trusts have started to gravitate more towards knowing what parcels they would be interested in before they are offered to them. So things do kind of just come up, continue, and land trusts do need to be nimble and take advantage of opportunities. But they are more than ever strategically focused on what it is they'd like to protect.
All right. The next question I see in the chat is from Rennie. Is it possible for conservation easements to be challenged after a certain number of years?
I think I need more clarification on that question. I mean, the answer is yes, but I'm not really sure what is motivating the question. So, who would be the challenger, or, maybe somebody heard something. So, Rennie, if you want to, I see you talking. Do you want to unmute for a moment?
Okay. Yes, we have 39 acres along the shorefront in West Haven, Connecticut. It's beautiful. It's an easement that's in perpetuity, but there's several people within the city. They keep saying we need a referendum, we need to change this, and we can take the property. So they already own the property. They're our partners, but I'm just wondering because some people say, well, we can challenge it. Can they? And if so, under what conditions?
Next week, we'll talk a little bit. I have to say, I'm pretty unfamiliar with, eminent domain and, other proceedings where, municipalities or public authorities may try to take possession of property that is restricted. A private landowner challenging that would, you would fight that. That would be, you would defend that, and that's your obligation to do so. There's, I think, precedent, the other way for public authorities, and the practices. There are some considerations in the practices about making sure, if you can, that you protect conservation values and get a proportion of any proceeds that are distributed. But I think the recognition among the writers of the standards and practices that you may not prevail, and it might not be worth it to, to expend all of your resources trying to fight an action like that. But we'll try to. I'll try to do a little bit more before next week, so
Okay.
So I have more to say.
Thank you.
I do say, I don't know, Rebecca, I just know that it's kind of a CLCC practice, and I like this too. You've given me an hour of your time. I do want to give those of you who, who want to move on this evening, permission to go. Our hour is up. I'm also perfectly comfortable staying here and answering more questions if you want to chat after the time is over. So maybe we should just call attention to the announcements that you've put in chat, and then I will stay on, once we formally close.
So before folks leave, I'll just let you know that if you go to our website and look under the, we have a whole series of workshops coming up. After Connie's series is done on Bootcamp, we're going to launch into a land trust law school series with several other attorneys. Connie's an attorney too. And one of them will be to review the model conservation easement and talk on an intro level about some of the questions that you've raised tonight as well. And then we'll have an advanced session. So keep those in mind as you're watching the schedule, and feel free, of course, to register. But thank you all so much for coming. And I guess I'm going to hang here for a little bit too. So thank you, Connie, for that generous offer to hang on. If you have some other questions and you want to unmute yourself or participate through chat, we'll hang around for a little bit. But thanks to all of you for coming.
And I do want to note that we will be following up with materials that'll include all the links that we included in the chat, which I know we had some statutes and some links for the CLCC website and resources. So I will follow up with those very shortly. So Connie, we got a couple more questions in chat. I don't know if you have seen them come through, starting with Joe at New Hartford Land Trust. Or do you want me to just go ahead and read them out?
If you could read them out, that's really helpful for me.
So Joe asks, how recent does an appraisal need to be relative to the closing?
That's a really good question, because there are timing requirements. And so, what the regulation says is that your appraisal, the valuation, and so I kind of want to make a distinction here between the date that the appraisal is delivered to you or may be delivered to you, and the date of the valuation, which kind of sets the value as of a specific date. The date of the valuation can not be any later than the date of the donation, so the date of the closing, and it cannot be any earlier than 60 days prior to. So most appraisers that you're going to work with know that, but it is a good idea to make sure that they realize that and that they can set the valuation date accordingly.
All right. And then the last question I see right here is from Ellen. Is it common for land trusts to partner with other nonprofits to acquire a conservation easement?
So other land trusts, I think that is getting more common. I mean, you know, look, so many of us need to partner in order to do the most impactful land protection. And so for a really large easement, it's, I would say, increasingly common to have partners, including, you know, partners at the federal and the state and maybe even neighboring land trust level. And we all know, of course, that, you know, that birds and other wildlife don't stop at town borders. So if you're doing conservation that spans more than one town, you know, that it is really helpful to have partners working, you know, in many different municipalities and forms on a project. And I guess what I would say about that too is that in most cases, you would have like one primary holder, and then you might name other partners as a backup holder, so that you're not really having, you know, you'd never have the case that like 5 different organizations were monitoring and, you know, duking it out around, you know, the stewardship of the easement. You would have one primary responsible.